Probate estate administration. Essential documents. Very important to understand that the financial durable power of attorney is the most important document you could have in your portfolio. If you, I won't take show of hands, okay, so don't get scared about that. But if anyone in this room does not have a financial power of attorney, promise yourself that before the end of this month you will have one. Because if a disability comes your way and you don't have an agent named, like you do in that document, you'll become a ward of the court. And the court will tell you what to do.
Is that a specific power of attorney, or if you have a kind of a standard durable power of attorney, does that cover financial?
Okay, there are 4 documents and page here.
Yeah.
The financial is 1, the health care is 2, living will is 3, and last will and testament is 4. The first 2, financial power and the health care, are both durable. Durable meaning even if you become incapacitated, it's a good document, okay? So they're both durable, but you need one for finance, one for health care.
So I have one for health care and I have a general power of attorney.
Yeah, that's
Does that
typically
cover the
finance.
financial? Okay.
Yeah, typically it is. If you have one, what you do, go home and read it. Make sure that general financial power of attorney has the power to gift and the power to self-deal. Very important to have in that document, as well as having the HIPAA waiver. Yes, putting a HIPAA waiver in a financial document is important because inevitably medical records lead to costs and financial. And so if you say, well, I want to know what that operation cost mom and dad, well, are you cleared under the HIPAA waiver? No, I'm not. Well, we can't tell you. Well, I've got my financial power of attorney. I don't care. If you're not cleared through HIPAA waiver, we won't reveal it to you. Okay? So what I do with my financial power is I put that HIPAA waiver in that. That's very, very handy to have. Now the second document is the healthcare power of attorney, and you can see right there I have with the HIPAA waiver. It is a mystery to me why the state of Ohio, with their standard healthcare document that every hospital, clinic, dental office has, does not have the HIPAA waiver in that document. I mean, I use the standard healthcare document that every hospital recognizes, every doctor recognizes, because I don't want my clients going to a hospital and say, oh, what's this document? It's my healthcare. Okay, let's shoot it up here to legal department. 3 weeks later, they'll make a decision, right? Okay, so you don't want that. So I use the standard document every hospital recognizes, but I put in it the HIPAA waiver. Okay? And I'll tell you, it's very important. I have a client up in Allen County, that's Lima, Ohio, and she and her husband were married for over 55 years. He unfortunately is severely disabled in a nursing home, and she goes to visit him every day, same time, it's usually in the morning. And she went in this one morning, and all of a sudden his face was black and blue all over. She goes down to the administration of the institution. She says, "What happened? Sorry, we can't tell you the incident report because you don't have a HIPAA waiver on file." She's been married 55 years. It's her husband. She can't get that report? You know, I'm lucky I wasn't in the presence, because I would have, you know, maybe had an assault charge against me or something, you know. She called me and I talked with the agent, and they hadn't read the document. In my document, which these clients had, the HIPAA waiver was in it. So I told them to take the document out, turn to page 4, there's the HIPAA waiver, and everything was good. But I'll tell you, institutions now are hiding behind that privacy law under the HIPAA waiver. Yes?
How long are they good for?
Oh, excellent question. Excellent question. Properly drafted and executed powers of attorney are legally good until they're revoked. Okay? However, most financial institutions, banks, insurance companies, investment companies, do not want to honor a financial power that's more than 5 years old. And the reason is this: the financial power of attorney is the #1 document for financial abuse of seniors. It is, you know, it's a powerful document. It's necessary, but it can be used for abuse. So the financial institute is doing what? They're they're protecting their own liability, aren't they? Okay? And they're saying, no, you need to get a new one done. Well, sometimes the person doesn't have capacity to sign a new one, do they? Right? So then I get involved and we talk through that. But I advise my clients, yes, it costs a few bucks, but every 5 years, have your financial power renewed. It's just that simple. Because more and more, it used to be only a few incidences. Now it's rather commonplace that they ask for a power of attorney that's 5 years or
How about wills?
no. If you've done a will 25 years ago and your wishes are the same, then that's fine. But keep in mind, a lot of what's involved with estates and wills and probate is all tax law, and there hasn't been 1 year since 1952 that tax law hasn't changed. Did you know that? Not 1 year. So if your estate is complicated with respect to taxes, you ought to have the will looked at about every 5 years because of those tax law changes. Okay.
A power of attorney, that's good only until the person dies.
That's correct.
Okay.
The power you give your agent ceases upon your demise. Absolutely right. Yes.
It sounds like it would be a conflict, but can you have more than one power of attorney?
You sure can. The conflict is there certainly because if you have two agents named and they both have originals, then one could go to the bank and say, I want to take all the money out, and the other one says, I just want to write a check for mom over here, right? Mm-hmm. And so which one is the bank going to believe, right? They both have a valid document. Okay, so I recommend alternate agents, okay, but no copies. One original, you keep the original, and the people that you trust know where it is, and so on. You don't want to appoint anyone in that document you have the least doubt about their trust, okay? It's just too powerful a document to do, okay? So I had a client, he was a very wealthy physician, MD, and his wife was the power of attorney. I did not do those power. They came from Cleveland down here after all that was done. And all of a sudden, his wife died in her sleep. And he was fully disabled with Alzheimer's and could not sign any other document. And so without an alternate on that power of attorney, we had to go down to the guardianship court and have the two daughters named as co-guardians. So, and all of his assets had to be outlined in front of the court. It's all public record, and it's just not a preferred state of affairs. So please have alternates on your powers of attorney. Okay, the living will is a document that you most of you know about. It's not any appointment of agent, but it's a statement of preference for whether you want unusual life support if you're in a terminal condition or not. And so, it's there. The state of Ohio has you executed. It is important. But I can tell you, in my 14 years, I have never experienced a doctor going against the family's wishes, even if there is a living will. If the family's unanimous, okay, but if the agent, the healthcare agent, is following the living will, the doctors usually follow that, okay, but they have a family meeting, and the doctors are usually very, very good about getting consensus for action when a living will is involved. And of course, the last document is your last will and testament. Very important for everyone to have, but I don't want anyone here to have their family go to the probate court with their will. The probate court is where it takes the will and says, okay, in the will you say you want this cup to go to this person and this paper to go to that person, and you can do all that privately. So I recommend getting a plan in place to do that asset distribution upon your demise in a private way, so you have less cost and less time for your family to spend on the asset distribution. All right.
Would you say that again, please?
Sure. A will states your intention with respect to who do you want to have your personal property or your personal effects or your assets, right?
Yes.
Real estate or whatever.
About that.
Okay. And if you use the will to do that, it's effective, but it will go through probate court in Central Ohio, it will cost you anywhere from 5 to 8% of the estate, and it will cost you 12 to 18 months of time. Whereas if you set your plan up appropriately in a private way, you don't have to go to court at all, and it might take you 8 to 10 months. So you save time. The cost instead of 5 to 8% is usually 1 to 2, something like that. So you save considerable time, considerable money in a private.
So when you say in a private way, you mean setting up a trust?
That's one way. We're going to talk about that right now, okay? And I will use that to get us as a segue. In the state of Ohio, $338,000 is the exemption amount before they impose an Ohio estate tax. The Ohio estate tax is 7% of every dollar in the state over and above $338,000. So even if you avoid probate, you do not avoid that tax. And I have people coming, oh, we don't have to file taxes. We avoided probate. No, that's wrong. If you avoid probate, that's one thing, but you cannot avoid tax unless you distribute that asset during your life to somebody else. Okay? We'll talk about that divestment later. Now, how do we avoid probate? The next thing, naming beneficiaries. If you have under $338,000, you can have joint ownership. POD stands for pay on death ownership or transfer on death ownership, and that means those assets named with those beneficiaries will avoid probate. And if your estate is under $338,000 as a net estate, there's really no good reason to have a trust necessarily, unless it's a complicated distribution. But the POD, TOD, and joint assets will get those assets out without any delay or delay in distribution. And of course, there's no tax to file because it's under $338,000. If you have over $338,000, trust, as you mentioned, is preferable because you gather everything together, pay the taxes, and then distribute out. Okay? So you had a question.
If you have $1 million and you're dividing among 4 children, they're each getting $225. Does that count as $1 million or is it $225 per child?
The estate is calculated on the total estate of the deceased,
So
the
that would be
net
$1
estate of the
So it's
deceased.
the $1 million.
1 million, and so it's subject to Ohio tax. So in that kind of estate, I definitely would have a trust to collect everything in, so that at that person's death, we liquidate or in the trust, and the successor trustee pays expenses, pays the taxes, and then distributes out to the 4 beneficiaries.